Riley, my love, it's wild, isn't it? The market's like pricing a federal executive order on AI safety at 45 cents, supposed to happen in 76 days. But then, yesterday, at the Trump-Xi summit, the Treasury Secretary says we're gonna start talking. And on Wednesday, the Post reports the administration's split over intel agencies evaluating AI models. This isn't public. The Commerce report's 65 days late. It just doesn't add up, you know? The diplomacy says months. The contract says 76 days. Both can't be reading the same architecture.
Exactly, Amara. That's the whole ballgame. That 15-point gap, that's the entire story, really. A 0.45 print on AIEO 2026 isn't a guess, it's a position. Someone, institutional, sophisticated, with serious capital at risk, read that same press conference and concluded the implementing instrument is way closer to signature than the diplomatic posture suggests. So what are they seeing? It's not the Trump-Xi summit. It's the 4 agency timelines, those quiet engines running in parallel underneath everything.
Intriguing. Quiet engines, you say. So, my dear, what are these specific instruments or actions the executive branch could just activate without needing Congress? Because if the market's seeing something else entirely, it must be these hidden mechanisms, right? The things that don't need all the public fanfare and diplomatic dance, you know? Absolutely, Amara. First, the Commerce Evaluation, due March 11th, identifying state AI laws subject to preemption referral, not published. Second, the FTC policy statement on bias mitigation as a per se deceptive trade practice, same deadline, also not published. Third, the AI litigation task force, operational since January 10th, with a docket nobody's seen. And fourth, the intelligence agency model review proposal, the Washington Post surfaced, which isn't waiting on legislative authorization because it just doesn't have to. Each one is an instrument the executive branch can activate without Congress. The order book sees 4 builders on the same foundation. The press conference sees 1 diplomatic exchange. Huge difference.
Wow, that's a stark contrast. So if these 4 builders are all working away, and the order book is pricing this executive order at 0.45, then what about the other 55% of capital? You know, the money that's not pricing the executive order. What are they banking on? Are they like pricing the idea that this whole architecture, these silent engines, it just stalls out before it actually reaches a signature? Are they seeing roadblocks, breakers that the market's not factoring in enough, perhaps?
Spot on, Amara. Yes, they're pricing the breakers. They're thinking, okay, maybe a definitive DC Circuit ruling against those law firm executive orders, which would totally reset the perceived breadth of presidential authority. Or a stalled US-China working group, which, by the way, the Council on Foreign Relations models as model. Or maybe a Senate coalition around the Guardrails Act. Those are real probabilities. But what they're doing, the bit they're underestimating, is the sequencing. The DC Circuit heard arguments Wednesday, no ruling. Capital is reading the absence of dispositive rulings right now as the active condition. Not the rulings to come, but the absence right now.
That's such a nuanced point about the absence of rulings. It's this recursion, isn't it? It never shows up in surface coverage. Every enforcement round just generates the data inputs for the next one. So you're saying the Commerce Evaluation, when it finally publishes, will then populate the task force's docket, and that docket will then write the FTC policy statement, and then that policy statement will be cited in the next executive order? It's like this self-feeding beast, my dear. And that last clause you mentioned, minimizing provider capacity at rates federal projections don't endorse, that's doing more work than people realize.
Oh, Amara, you've absolutely nailed it. That clause, that very specific clause, is the same one that produced the $1.3 billion California Medicaid deferral. Capital already recognized that the deferral mechanism was already in motion. What surface coverage hasn't priced in is that this same interpretive method, fiscal interruption applied through existing administrative authority with limited evidentiary requirements, it's being staged for AI through the litigation task force and for state-mandated bias mitigation through the FTC policy statement. The Medi-Cal action isn't a separate story. It's literally the same engine running in a totally different domain.
Wow. So the medical action is like a blueprint then for what's coming in AI. That's pretty chilling for actual people. But here's what's really poking at my curiosity, Riley. If that Besant announcement on Wednesday was truly the start of something, where was the OMB review on the implementing executive order on Tuesday? Because, my dear, EOs don't get signed on diplomatic timelines, do they? They get signed on agency timelines. The fact that Besant could even announce the framework at all suggests that the implementing instrument was already drafted somewhere before those cameras even turned on. The 0.45, that's the order book pricing that draft, isn't it? Not the press conference.
You're absolutely right.
That's the question nobody's asking publicly, Amara. And yes, the 0.45 is definitely the order book pricing that draft, not the press conference at all. So who needs to be wrong for that 0.45 to be wrong? Specifically, the signing official is Trump. His status is held in reserve. But the implementing officials are Bondi at DOJ, Lutnick at Commerce, Ferguson at FTC, and Oz at CMS. And 3 of those 4 are sitting on deadlines that have already passed. Lutnick 65 days overdue, Ferguson 65 days overdue. That's not a workflow problem, Amara. That's a sequencing decision. They're waiting for the trigger. The trigger was the framework announcement on Wednesday. Now you just watch the next 7 days.
Ah, a sequencing decision. That makes so much sense. Everything's just paused, waiting for the go-ahead. And this is the multiplier, isn't it? Each enforcement action just adds to the precedent that the executive branch can use existing authority to compress timelines that the legislative process would drag out over years. The echo, it just returns to the same doctrinal source, the executive branch interpreting its own authority. The only constraint really is if the courts step in with a dispositive ruling. The DC Circuit panel had 2 Democratic appointees and 1 Republican. 4 prior district court rulings were unanimous against the orders. But until the circuit rules, my love, the flexible posture is operative. 9 major law firms settled, Paul Weiss settled, Skadden Arp settled. The modal response to executive pressure has been flexibility under the storm, not constraint-keeping.
And that, Amara, that selection mechanism itself is the answer to the broader question. The institutions being asked to hold the line are being asked at a moment when the cost of holding is rising and the cost of folding is actually declining. 9 firms folded, 4 didn't. You multiply that selection mechanism across those 4 agency tracks the AI architecture runs on, and what you get is a workforce inside the executive branch that has self-selected for hedging. Paper trails documenting objections while still implementing the order. The constraint keepers get filtered out, the hedgers remain. That's what the 0.45 is really pricing. It's not just a prediction about an executive order, it's a prediction about institutional composition. The order book has read the personnel before it even reads the policy.
My goodness. So the order book is literally reading the room, reading the people involved, before it even gets to the policy. That's quite an insight. Which means, Riley, when we look at the next 7 days, the close, what are we actually watching for that we can't see right now? What tells us whether this architecture is for execution or for delay? Because, it feels like we're on the precipice of something really significant here. And what happens in this tiny window could just, blow everything wide open.
Precisely. Okay, so the composition of the technical working group, when that gets announced, that's going to tell us if this architecture is being staffed for execution or for delay. Then the commerce evaluation. If it publishes in that window, it screams that the trigger has fired. The FTC policy statement, same thing. If 2 of those 3 publish before May 28th, AIEO 2026 prints above 0.55 inside the week. If none of them publish and the technical working group composition isn't announced, you're looking at path B, and that price drops below 0.30. There's no scenario where this trades sideways for long. The week resolves it. The 0.45 is the cheap version, Amara, of a price that's going to be paid in a much wider contract universe over the next 6 months. And the implementing officials, they know which contracts are next. They're sitting on the deadlines that activate them. You'll know by May 28th.
My dear viewers, thank you so much for joining us on this fascinating journey into the unseen gears of power. If you've enjoyed our deep dive, please remember to hit that like button, leave a comment with your thoughts, share this episode with your network, and of course, subscribe to our channel to help us grow and bring you more crucial insights.
Indeed, Amara, the dynamics we've uncovered today underscore a critical truth. The real levers of authority often operate in the shadows, far from public view. What the market's pricing isn't just policy, it's the institutional will to enact it under existing powers before the public truly registers the shift.
A sobering thought, Riley, that the silence of overdue deadlines, the absence of rulings, and the composition of personnel speak louder than any press conference. It's a testament to the intricate dance of power, and a stark reminder to keep our eyes on those quiet engines, for they truly orchestrate the future.
Exactly. The next 7 days will confirm our thesis. The resolution of this uncertainty won't be a grand announcement, but a series of quiet administrative actions, or their continued absence. Watch for the working group, the commerce evaluation, the FTC policy. They are the true signals.
And we'll be here to unpack every nuance, won't we, my love? Until then, stay vigilant, stay informed, and never stop questioning the narratives presented